Hello everyone, I am Leonard French, your favorite copyright attorney, here to talk to you about the Watchtower Bible and Tract Society of Pennsylvania. That was news to me. I didn't even know what that was. It's not even a lawsuit. It's just a subpoena, but it has to go through a federal court, so it looks a lot like a lawsuit. Their DMCA 512H subpoena to Reddit for a Redditor's identity. Welcome everybody. Let me get my chat up here on the screen so I can say hi to everyone. Australia says hey, says James Denholm. Welcome. Welcome Gerald, welcome Nicholas, welcome Will. Ona and Alto Mare, or Alto Mare. J. Lou. Welcome. Thank you, Ono, for the $1. Thank you, Matthew East, for the $5. And Ono, another $1. And Adolf. Yes. Adolf Hitler has given $5, everyone. Mm. What a pleasant name that is.
Thank you, Hitler.
Also, I quickly want to say for the people who commented if my cat ever moves, as you can see, she moved and she's behind us now.
Yep, and if we're lucky, we will see some more life out of that cat, or there's another one who's just off frame over here, but she's sound asleep, so...
she's not. The moment you said quiet on the set,
literally the moment I said that, she's now moving, so you might find another cat
when you said
flying across the
set,
screen here.
She started moving rapidly around, that's why I tried not to laugh.
So welcome everyone. Just a moment longer for everyone to get in to the stream, and then we will start with this right here. This is the opposition to the motion to quash that is not really scrolling very cleanly on my screen here. Thank you, Microsoft. Here, let's go all the way up. Watchtower Bible and Tract Society of Pennsylvania's opposition to Darkspilver's motion to quash. That's what we're gonna go for. Mark gives $10. Thank you, Mark. Flying cat is flying. Excellent. That was Now by AGST, the introductory song, if that was actually coming through. I hope it was. And welcome, everyone. Joining us today, Brandon and Tactical and Ms. Kaylee are with us here in the studio. Hello, Andrew Hera. Thank you for the $1. And now, if you've seen, I tried to time this. I tried to be clever about this for you. I have no idea whether this worked for you or not. We're just trying this. I released the first part of this video about a day ago, and then scheduled the live stream for today for the second part. The first part, if you haven't seen it, was the motion to quash filed by the EFF. Now, if you haven't seen it, you're probably okay skipping that and just watching this live stream, because we're going to discuss a lot of that on this stream. Thank you. Oh, I see. I was wondering why Ono got hidden there for a moment. Yes. So I get it now. All right. So what has happened? Let's bring you up to speed on what has happened so far here. This is the docket for the case. This is what the dockets look like from either Pacer, if you are a Pacer user, or if you are a lawyer user. It looks similar to this, but has extra options in the top. For example, I'm not admitted to the Northern District of California. When I go into court in California, I use local counsel, just like you'll see in this case. And so I just have the normal Pacer login here. This is the docket for the case, and the first thing I notice when I see it is that it says MC and not CV. So this is a civil matter, but it is considered a miscellaneous case. Hopefully everybody can see that, what I'm highlighting there on the screen. What happened here is there's a law. 17 USC 512 is part of the DMCA, the Digital Millennium Copyright Act. The act itself actually creates several sections of Title 17 of the U.S. Code. 512 is what's called the Limitations on Liability Relating to Material Online, or the DMCA. There's also Section 1201, which we're not going to discuss today and is not part of this, but 17 USC Section 1201 is also part of the DMCA, and this is all about circumvention of copyright protection systems. Not discussing this today, just wanted you to know how the DMCA falls into that. The DMCA in Section 512 creates various safe harbors, or should I say requirements to maintain yourself in the safe harbor if you are a content host and you want to stay out of copyright infringement lawsuits for the copyright infringement, or should I say alleged copyright infringement of your users. So, for example, we went over this in the last video. We have transitory digital network communications. We have limitations on liability for such. We have information residing on systems at direction of users. All of this is about user-generated content and the safe harbors for the system's providers. Then we get to Section F, which is an important section for any of you who have ever heard of or been outraged by the various takedowns you may have seen on YouTube, where somebody gets taken down for no reason, or maybe just so that some other user or company gets their monetization. When they receive a notice like that and it is false, a false DMCA takedown notice, they would have the right to sue under this section, DMCA 512F, misrepresentations. But again, that's not what we're talking about today. So what we're actually going for here is Section H, a very little known section. It's used often, but it is not seen, it is not in the news very often. And it is a subpoena that can be sent to identify an infringer. A copyright owner must simply comply with these sections here. So it says a copyright owner or person authorized may request the clerk of a United States District Court to issue a subpoena. And that's what we see here. This is a civil miscellaneous case. And I just messed that up. A civil miscellaneous case. It is not a lawsuit. It is just a subpoena. Back here, it says that the request must contain this information, a copy of the notification described in subsection C3A, which is up here someplace. I'm assuming that is one of the notices. Up here. C3A, elements of a notification. So that's the same information as a takedown notice, must be included in a 512H request. And then the proposed subpoena must be in there, and a sworn declaration to the effect that that the purpose for which the subpoena sought is to obtain the identity of an alleged infringer. The subpoena shall authorize and order the service provider to expeditiously disclose to the copyright owner or person authorized by the copyright owner information sufficient to identify the alleged infringer. In this case, it's a username of Reddit on Reddit. It's a username on Reddit, and they are asking for, I guess, any identifying information that might be behind that user, maybe an IP address or something. For all we know, though, we don't actually know if Reddit has that person's real first and last name and address and all that. But maybe they do. And there's really no way to find out unless you get the subpoena, so you've got to ask. The basis for granting the subpoena is if it satisfies the notification requirements in C3A, like we said above, if it is in the proper form and the accompanying declaration is properly executed, the clerk shall issue and sign the proposed subpoena. Actions of receiving the subpoena upon receipt of the issued subpoena, either accompanying or subsequent to the receipt of a notification, etc. The service provider receiving the subpoena shall disclose the copyright owner or person authorized by copyright owner, notwithstanding any other provision of law, or whether the service provider responds to the notification. And then there's some more rules here. The procedure for issuance and delivery of the subpoena and the remedies for noncompliance shall be governed by the Federal Rules of Civil Procedure. So that means that we have all the rules of law available to us, including the rules about quashing or vacating or otherwise invalidating a subpoena. And so that's what's happened here. When your service provider gets a notice under 512H, they have to notify you and give you a due process right to respond in a meaningful way in a court of law and have the court adjudicate that request fairly. So once, and you can see this on the docket here, and I'm going to keep screwing that up because I'm using the back button. you can see this on the docket here. The request went out on January 9th, or the request went to the court on January 9th. They granted the subpoena on January 16th, because it must have met all the technical requirements. And then suddenly, or not so suddenly as you'll see in their argument, March 26th, there's a notice of motion to quash filed by the defendant, Darkspilver, through, I believe it was the Electronic Frontier Foundation. Yes, here it's listed here, Electronic Frontier Foundation. So, let me take a moment here to thank all the people who are donating. -74, thank you for your $5 donation. Prenda Law, whoever you are, thank you for your $2.
Got a feeling.
Andrew, $1, and Stan, $1. Thank you very much.
Also, one person was asking how much it will cost to file the subpoena.
How much it would cost to what?
File the subpoena to.
I believe it's like $95 was the price here. Let's see, it should say it somewhere here. Yeah, $94. Filing fee of $94 is listed right here on the docket. So that's what it cost. The filing fee was $94. So you could do this too. This is a procedure that's available to everyone. If you have, and I would suggest you'd only do this for valid infringement, but if you have an allegation of valid infringement against somebody, you can uncover their identity. And don't we really want to know the identity of someone from a certain, what was it? What was the organization that posted our fake cop video?
Oh.
That was World Star Hip Hop, I believe.
Yeah, something like that.
And there was a user that I believed was an employee or contractor or other authorized agent of World Star. I think maybe I'll use this procedure instead of filing a $400 court matter. Let's think about that. So, where are we here? So let's go over to their opposition. And now, what are they opposing? They are opposing the motion to quash. Well, what the heck is a quash? It's a bit of a weird term of art. It does kind of mean squash. So I kind of like allowing people to, when someone missays it and says, oh, I want to file a motion to squash, I laugh a little bit, but it's not that far off. It really are. You're kind of squashing the subpoena. You're kind of flattening the subpoena. You're asking the judge to invalidate the subpoena. And in doing so, that would really eliminate the case, because Watchtower Bible really can't go forward with their case unless they have the identity. So that kills the case. Now, you're going to see, though, that judges understand that, and judges don't want to grant dismissals so quickly. So let's take a look here. I'm going to page down a few times because there's a lot here. We're going to skip their summary of their arguments and go straight to their introduction. And remember, this is Watchtower Bible. These are the people who are seeking Darkspilver's true identity through Reddit. And they are opposed to the Electronic Frontier Foundation's efforts to stop them. So they say, to defeat the clear intent of the law protecting copyright holders, Darkspilver attempts to convert this intellectual property matter into a religious dispute by seeking refuge behind the First Amendment's freedom of speech protections. This case is not about suppressing his or her public criticism. He can say whatever he desires. However, he cannot infringe Watchtower's intellectual property in the process. For years, Darkspilver has been discussing and debating matters related to Jehovah's Witnesses freely and openly with people who have a wide range of views. And it looks like they're citing his declaration where he says that he's, I believe exactly that quote, that he's discussed matters related to Jehovah's Witnesses freely and openly. Watchtower says they've never taken any legal action against his years of voicing disagreement or doubts about Jehovah's Witnesses' teachings or practices. However, when he chose to infringe upon Watchtower's intellectual property, he triggered legal protections that are accorded to copyright owners. Darkspilver now seeks the right to anonymously infringe that property. If he prevails, he will effectively be immunized from all future copyright infringements. Further, all other users within this court's jurisdiction could similarly thwart the plain intent of the Copyright Act by contending that they too have a fear of reprisal. Thus, Watchtower would be stripped of its intellectual property rights in all such cases. Darkspilver would have this court believe that Watchtower Bible and Tract Society of Pennsylvania, hereinafter Watchtower, has undertaken a witch hunt targeting the free speech of the entire community of former and current Jehovah's Witnesses who criticize the Jehovah's Witnesses' religion using the Reddit service. Yet, of the 34.1 thousand members of the r/xjw, EXJW is how that's spelled, subreddit forum to which Darkspilver subscribes, only Darkspilver and one other Reddit subscriber are the subjects of Watchtower's subpoenas to Reddit. This is because only Darkspilver and one other subscriber are accused of infringing Watchtower's copyrighted works. If the court denies Darkspilver's motion to quash, it will send no other message than this: you can criticize Watchtower as much as you want, as long as you do not infringe their copyrights. Now, I don't know about you, but I've noticed a thing or two in here already. There's a few things that I have a problem with in what they've said, but I don't want to pounce on them too quickly, but let me just take a quick pause here. If the court denies Darkspilver's motion to quash, sends the message that, quote, you can criticize Watchtower. Now, we know this is going to involve a fair use argument at some point, right? We know that from the previous video that the EFF is leading with a fair use argument, and sort of secondary arguments are religious freedom, that the fair use argument is supported by religious freedom, as well as kind of an independent religious freedom argument. Doesn't this say criticize? And isn't criticism a core part of fair use? I'm not judging it yet, but let's just keep that in mind. And then back up here, this makes it sound where it says Darkspilver now seeks the right to anonymously infringe that property. It doesn't seem to say much about whether there's a fair use or not. It's very conclusory. Okay, maybe we're in the introduction. It could very well be, they're going to talk about this more. And then they say that this motion to quash is time-barred. By a time-barred motion to quash, Darkspilver seeks to shield admitted infringement of Watchtower's copyrighted works by invoking First Amendment rights to which he is not entitled in a court that, by his own admission, does not have the requisite personal jurisdiction to adjudicate the copyright infringement claim. Okay, they filed the case. Wait a second here, gotta back up again. There's a section here, there's a line here that says something about personal jurisdiction. By his own admission, we don't have personal jurisdiction. But they filed the subpoena in this court. He's responding in this court. That's enough. That's all we need. Yeah. He's not suing them in this court, and this isn't a lawsuit. So he's responded in the proper court. Under the cloak of fair use, there we go, finally got to fair use, Darkspilver's untimely motion to quash also invites this court to foreclose copyright protection to all non-commercial works. That's okay. I don't think that's what he said, but fair enough. We'll hear their statement. Should the court accept this invitation, it would essentially write non-commercial creative works out of the Copyright Act altogether. I guess we'll get to that argument in a bit. So their statement of the issues to be decided are whether the First Amendment rights to anonymity protect copyright infringement, whether a non-resident foreign national with no presence in the United States is protected by First Amendment, whether Darkspilver's motion to quash is time-barred. That one right there sounds like that's the first major, that's an argument. I hear that. Whether Darkspilver as the movant has satisfied his burden to proof. Okay, that's fine. That's a standard he has to meet. When you file a motion to quash, you must meet the burden of proof, or burden of showing you are entitled to the quash. 5, whether Watchtower is entitled to compliance with the DMCA subpoena. Okay, that's the ultimate conclusion, whether or not we're going to have that, and whether an evaluation of fair use is appropriate at this stage. So that's also a question I have. If fair use is even something that a judge can do something with at this preliminary stage? Does it matter whether it's a fair use or not? Do they still get to uncover the identity? Now, what I think is really going on here is that we have one of two things. Either is this a true copyright infringement suit that just happens to involve a religious organization against a former or soon-to-be former, if they catch him, member of the Jehovah's Witness organization, Watchtower Bible and Tract Society of Pennsylvania? Or is this a religious persecution situation? I think this is a very important question to ask, and I'm hoping that the judge will take this question seriously, even at this preliminary stage of litigation. Because, as we've seen with the EFF's motion to quash, Dark Spilver is very concerned that there will be additional consequences beyond just copyright infringement or whatever if Watchtower gets their identity. Whereas, from Watchtower's perspective, they claim that they saw copyright infringement and just don't want their copyrighted works out in the open. And we're going to look at these copyrighted works too. I have both of them, and we're going to look at what this is. The issues to be... we saw the issues to be decided. So now, Dark Spilver allegedly reproduced and displayed several copyrighted works owned by Watchtower on the r/EXJW subreddit, which I'm just going to call the XJW subreddit. One of the copyrighted works reproduced and displayed was an article titled, "What Gift Can We Give to Jehovah?" Now, I think it's important that we look and see what was allegedly infringed. And so this is Exhibit A to Dark Spilver's motion to quash. And this is the alleged article. "What gift can we give to Jehovah? Jesus once said there is more happiness in giving than there is in receiving." Happen to agree with that. "That basic truth applies to our relationship with Jehovah." Well, when I'm the one giving to someone else freely, but when I'm telling someone, by the way, you should give to me because Jesus said it was right, that's where I start to go a little bit like, wait a second. No. You're not freely giving if you've asked for the gift. Yeah. That's not a gift. Jehovah has given us many gifts that make us happy, and we can derive even greater happiness by giving a gift to Jehovah. Okay. And that's their belief system, and this then has further ways to make donations at donate.jw.org. You can set up a recurring donation. You can find the JW Library homepage, click on the donations link. So this is just a very basic flyer that says, should we give to Jehovah? And now, I don't know under what context, then, this was revealed to the XJW subreddit. If Dark Spilver simply posted this back of this flyer to the XJW subreddit and offered no additional commentary, is that fair use? Probably not. And it's difficult to say whether... Even though it's a very minimal use, it's difficult to say whether a judge would actually hold that as a complete copyright infringement. We do have something called the doctrine of de minimis use. What is the damage here? There's next to no damage. So what is the Jehovah's Witness organization looking for? If someone posts a copy of the back of their flyer to a subreddit, well, how does a fair use analysis work? If there was no criticism or commentary, which I'm not assuming that at my end yet, but if there was nothing from Dark Spilver, then the first factor, the transformativeness or purpose and character of the use, it kind of fails there. However, this isn't a 4-step test where you fail at any step. This is a 4-step test that we balance. So we're also looking at the nature of the use and the nature of the original work. Is it a commercial work? No, it's a religious work. and it's a religious work asking for donations. Is it super creative? Not really. It's got different colors. It's words formatted on a page. It's paginated or whatever. It's formatted. It's got colors. Somebody designed it. So it's not like it has no copyright protection. But then what was the purpose and character of the use? Did the revelation of this, was it to spread some sort of what's the word I'm thinking of? Was it used? I'll skip ahead to the usurpation factor. Was it used in a way that usurps their market? Absolutely not.
No.
Their market is it's a free publication. This is on the back of a magazine that they publish, and it's a free magazine, and it's a magazine for the public, right? Tactical, I think you looked into this a little bit, right?
Yes, the magazines are available for download for free from the website as like PDF and such.
And they also hand it out.
Now, however, handing it out, putting it on a website, that's distribution. Or, I mean, if you were performing the work, you could perform it publicly, but we're not doing that. I mean, I'm sort of performing it publicly, but it's not being distributed illegally or something at that point. If it is being distributed by Jehovah's Witnesses, if it's on their news stand or whatever, those are all things that they control. If Dark Spilver is distributing it, that's not something that is something that they can control. That is a copyright under 106. It is a copyright, number 106.2 or 106.3, to control distribution of your copyrighted work. So they would technically have the right to control distribution. However, was this distribution supposed to be a usurpation of their work? Are people going to not look at the magazine, or if people were looking for the Jehovah's Witness Watchtower magazine, are they now not going to go look for the magazine because they found what they were looking for here on XJW? No, I don't really see that. I don't see it as a market usurpation kind of thing. So it's really kind of a weird fair use analysis. It's not for commercial purposes except in the sense that it's asking for donations, but that's not what we're talking about. Is usually a commercial work is the work itself is being sold. Yeah. Here the magazine is not being sold. So earlier today I told Tactical that the myth of a free magazine being freely distributable by anyone, you can still control the distribution of your copyrighted work. But here we're talking about one page of an entire magazine. So it's, of the how much and the substantiality of the portion used, factor 3, I believe, it's one page. It's the back page, but it's one page. And then the purpose is a religious work or something related to asking for religious donations. It doesn't seem to be criticism or commentary or transformation, but it also doesn't seem to be market usurpation. This is where I think it might even be such a weird fair use analysis that we might go to a different doctrine for this one. Thank you, Bobby, for the $1. We might go to the doctrine of de minimis use. The judge might find that the copyright use and damages are so minuscule that it doesn't matter. That this is not a copyright infringement because next to nothing has been copied here. There has been no tremendous art that's been copied. There's a layout of a page, some coloring, and some text asking for donations. Yes, that meets the minimum requirements, I think, for a copyrighted work, but I don't think it goes very far beyond that. And I think a judge could easily find this to be a de minimis use. But anyway, I want to go on with their opposition to the motion to quash. However, I wanted to have a good discussion about this particular item. And we're going to show you the next item in just a moment here as well. So, The What Gift Can We Give to Jehovah flyer was published on jw.org and also appeared on the back cover of the November 2018 issue of The Watchtower, which is their magazine. This infringement was reported to Reddit on December 19th, 2018. Watchtower also reported the infringement of an internal document not intended for widespread public dissemination titled C5829CA, hereinafter The Chart. Watchtower conducted a good faith, fair use analysis of several uses of Watchtower's copyrighted works by Dark Spilver on the XJW subreddit forum. Here they're going to be describing, you see, good faith, fair use, right? Mm-hmm. They're going to be describing why they think they're not in violation of 512F and making a misrepresentation. Watchtower concluded that the 2 infringements reported to Reddit did not constitute fair use. While these are the only 2 infringements that were reported, there are others that they did not pursue, allegedly. Then they go on that there are thousands of subscribers to our XJW. Watchtower has issued DMCA compliant notices before, and to a total of only 2 subscribers. Dark Spilver's speech was of no interest to Watchtower until that speech turned from critique to copyright infringement. Dark Spilver openly admits conduct that satisfies all the elements of a prima facie case for copyright infringement. That means all the basic elements of a copyright claim, but doesn't include fair use. So then, what is fair use? Fair use is saying, yes, I used your copyrighted material, but I have a defense of fair use. It's what we would call an affirmative defense. It admits that you did the thing, but that you have a legal defense otherwise. A extinguishing legal defense, a dispositive legal defense otherwise. Dark Spilver's claim that honoring the DMCA's subpoena provision will have a chilling effect on free speech is belied by statements of several members of the XJW subreddit community, who said, LMAO, chilling effect my ass, we're always gonna fight, always gonna be actually unconditionally support and defend our brethren, good luck shutting us up. Members of the community have also started to counsel the XJW subreddit community on how to use Watchtower's intellectual property. A general tip would be not to publish anything on social media that is a leak or unpublished work of Watchtower, or if you are doing that, it must be done from a neutral IP address and VPN to remove any danger of being outed, take privacy steps, or don't use their stuff. Now, this is a very interesting thing to include in the lawsuit, because this does not seem to be something that is relevant to their claims or Dark Spilver's defenses. And things that are not relevant would generally be inadmissible in court and could be struck by a motion to strike should the EFF file such a motion. The judge won't automatically strike these things. They would have to be proposed to be struck by a motion from the opposing party. Dark Spilver's claim of a chilling effect on the speech of the Reddit community is further belied by the increase in the size of the community. They're saying that that they were 5,000 new members in 6 months. They're saying that 2,869 users have contributed to a map cited by Dark Spilver that purports to show the alleged locations of XJW subreddit community members. I'm not sure why that's relevant either. Let's see, that's Exhibit D. Let's show you that map. This is the Exhibit D that they're... Nope, that's the chart. Where is...
It's D of them.
Is it Exhibit D of them?
Yeah.
Yeah. Let's try... Yep, this is the chart. So this is the chart they're talking about that 2,800 users have allegedly filled out, showing where the members of the XJW community are. So they're around the world, is what I guess they're getting at. Again, I'm not entirely sure how this is relevant to a claim of copyright infringement in a DMCA 512H matter, but okay. Watchtower is not Dark Spilver's local church and has no ability to excommunicate him from his local congregation of Jehovah's Witnesses. Okay, I don't know how they know that. Not a single person that has been the subject of a Watchtower sought DMCA subpoena has been excommunicated from the local church as a result of Watchtower obtaining their identity from a DMCA subpoena. Again, that doesn't seem to change anything. Watchtower has never publicly disclosed the names of individuals who were subject of DMCA subpoenas. Some of the subjects of Watchtower's DMCA subpoenas who were active Jehovah's Witnesses before they became the subject remain active Jehovah's Witnesses. So that means some, not all, right?
Yeah.
All right, so here's their argument. Were this case to be viewed through the prism of the Constitution, the appropriate starting point would be Article 1, Section 8, copyright, to promote the progress of science and useful arts by securing for limited times to authors the exclusive right to their respective writings. To subvert the well-established congressional protections accorded copyrights, Darkspilver asserts the right to anonymous free speech. In doing so, he ignores the fact that the U.S. Supreme Court, in addition to courts in both the Ninth and Second Circuits, recognize that the right to anonymous speech is not absolute. The First Amendment does not provide a license for copyright infringement. Thus, to the extent that anonymity is used to mask copyright infringement or used to facilitate copyright infringement, it is unprotected by the First Amendment. This presents a problem, and I recently argued this in court. So you go to court over something like this. The one party is saying, yes, you've committed copyright infringement, and the other side is saying, no, we haven't. So if I have a right to anonymous speech when it's not copyright infringement, and I don't have a right to anonymous speech when it is copyright infringement, what happens if you violate my rights by saying it's copyright infringement and then we later on find out that it's not copyright infringement, but you got my identity and you violated my right to anonymous speech? This is a conflict. This is a conflict in the law, and you're seeing the cutting edge of the law here. We have not really dealt with these problems before at great depth, and they seem to be dealt with on a case-by-case basis and on a judge-by-judge basis. I practice law around the country, both through admission and through pro hoc vice, through local counsel, and I get different rulings from different judges basically in the same case, because many of the cases I defend are the exact same boilerplate case of alleged copyright piracy using BitTorrent file sharing networks, demonetized. And this motion to quash issue comes up. Can my clients be anonymous from the public or even from the plaintiff? And a lot of courts say no. A lot of courts say, we cannot allow you to be anonymous from the plaintiff. The plaintiff needs to decide whether to sue you and will need to investigate your case. And even if your client says they're innocent, we're going to assume that the plaintiff's well-pled facts are true, which is the motion to dismiss standard, right? And if their well-pled facts are true, then that means a well-pled fact of copyright infringement is true, meaning we get to violate your right to privacy, which you never had if you were a copyright infringer, but you did have if you weren't. So at the end of a copyright infringement suit, shouldn't the successful defendant, when successful, when prevailing, not just get their fees and costs, but also get something for the violation of the right to privacy? My humble opinion. But let's go back to the meat of the matter. Advocates who are not citizens or residents of the United States and who are not physically present in the U.S. do not have First Amendment rights. Assuming arguendo that the right of anonymous speech is properly presented in this case, Darkspilver does not have standing to assert it. He is neither citizen nor resident of the U.S. and is not present in the U.S. Were this position upheld, every person on the planet would be granted the right to assert similar constitutional rights in federal court. This is a bit of a hyperbolic argument, if you ask me. It is true that citizens of the United States get certain rights that non-citizens who reside in the U.S. mostly fall under the Constitution, and that non-residents and non-citizens, non-residents who are non-citizens who fall outside the United States generally don't have U.S. constitutional rights. However, there is the doctrine of minimum contacts. And here we have Darkspilver using Reddit, an American company which has its servers or principal place of business in Northern California. I'm sure it has distributed servers all around the world, but its primary control center, its primary nexus of operation is in the Northern District of California or thereabouts, and Darkspilver is making use of those facilities. when Dark Spilver is accused of copyright infringement under U.S. law in a U.S. court using DMCA 512H, I personally find it hard to argue that they don't have any protections of U.S. law while they're being sought after under U.S. law. So it's hard to argue. It's hard to speak out of both sides of your mouth like that, if you know what I mean. Attempts by a non-resident foreign national to assert constitutional rights are not new. They cite Johnson V Eisentrager, a foreign national arrested in China after World War II, who attempted to obtain writs of habeas corpus in federal courts on the ground that their conviction for war crimes had violated the Fifth Amendment and other constitutional provisions. The court rejected the extraterritorial application of the Fifth Amendment. I don't know that the facts are the same here, but it's an interesting argument. They cite another case, U.S. v. Verdugo, U.S. v. Verdugo Irquidez. A foreign national was arrested in Mexico, then extradited, claimed Fourth Amendment protection when his home in Mexico was searched. Again, not the same facts here. We're not searching the home in Mexico. We're searching the Reddit server in California. So these will be arguments that the EFF will make, and make much better than I'm making them now on a live stream. And of course, I would make them much better if I was researching them for my client in my case. But we're just, armchairing it here, and have other stories to get to. And I really do have other clients to work on that take priority over me writing and researching things, at that level. So I'm not trying to do the EFF's job or anything. Mitch and everyone over there, I love you guys, and you know that I'm just having fun here. So, but the EFF will make the proper arguments, is what I'm trying to get at. The Verdugo Irquidez noted these cases establish only that aliens receive constitutional protections when they have come within the territory of the United States and developed substantial connections with this country. What did I just say? The court continued, respondent is an alien, etc., etc., etc. The Ninth Circuit also attaches constitutional protection for non-U.S. citizens only when they are present. In St. Andrews, Sons v. Mitchell, the court held any person within the U.S., resident or alien, is protected by the guarantees of the Constitution. No. Okay, guys, here's some philosophical logic, premise-based logic here. The Ninth Circuit, they claim, also attaches constitutional protections, and they say only to people who are present, but then the actual quote is simply that any person within the United States has these rights. Nowhere in that sentence does it say any person not within the United States doesn't have rights. No. It says if you're in the United States, you do. It doesn't say more. Yeah. So I think they're stretching that a little bit.
And I think this is part of what's complicated, is that the subpoena is to an American company, but the person who is sort of under threat of having their identity revealed is a third party. So the court jurisdiction in my head is like a little weird, because they're asking for to subpoena an American company, but that doesn't mean that the lawsuit would be in Northern California. If they wanted to pursue a copyright lawsuit, they might have to go to another country, or they might have to find some other way to sue this third party.
Or they would have to argue that the exact opposite of what they're arguing in this motion, hence my saying that they're speaking out of both sides of their mouth. If they later want to sue Dark Spilver, which I doubt they're going to do, I personally feel this is more of a seeking of Dark Spilver's identity. But let's say that they really feel that there is some actual remedial damage that they can get a court of law to remedy. Unless they're going to pursue Dark Spilver back to their country, back to Dark Spilver's country, because we know they're not a resident of the U.S., but we don't know where they are a resident, then they are going to have to find a way to sue them in the U.S. And they're going to say that Dark Spilver has established minimum contacts by posting things on Reddit, a U.S. company with servers in the U.S. using U.S. law. The exact opposite of what they're arguing now. So I don't think there's any way they're going to be able to pursue actual copyright infringement against Dark Spilver.
Yeah.
So this is a very interesting case because it looks like a copyright case, but when you open it up, it doesn't look like a duck, walk like a duck, and then is a duck. This looks like a duck, walks like a duck, but when you open it up, it's a mechanical automaton. Now, this is their best argument, I think, here so far, that the motion to quash is time-barred. Federal Rule of Civil Procedure 45 notes that the 10-day response period for a subpoena is extended to 14 days to allow a bit more time for objections to be made for quashing a subpoena. And here, Dark Spilver was served with a subpoena February 7th, I believe, and responded March 26th. Now, Reddit got the subpoena earlier, I believe, sent it to Dark Spilver, and then Dark Spilver eventually found the EFF, and the EFF responded. I have not had a lot of success arguing that small amounts of time should allow for either the dismissal of a case or the dismissal of a party's argument. You may remember the Alex Mauer case. The judge gave Alex 2 months to respond. She didn't, and I filed for default, and the judge denied me, saying that she was only late by a couple days. My argument, of course, that she was 63 days late because she had 60 days plus the days she was further late. But the judge did not buy that, and the judge denied my motion. So, is the judge going to necessarily grant that the motion to quash is late? I don't know. It's worthwhile. It's a spaghetti at the wall argument, and Watchtower has the resources to make the argument. So yes, you make the argument. While courts may at times be skeptical of subpoenas that do not allow for 14 days for compliance, when the underlying subpoena provides for at least 14 days, the deadline to file a motion to quash is the subpoena compliance deadline. Yeah, this is again, not true. We do this all the time in court. We receive notices that our clients have passed on to us, notices from internet service providers who have received a subpoena request, and those give something like 14 days. Rarely. Most of the time they give 30 days, and even now they're starting to give 60 days for a person to find an attorney, figure out their case, and respond to the subpoena. Instead, here, Watchtower is saying 14 days is enough time. Not every judge is going to agree that 14 days is enough time. There are no rules for when the subpoena requires revealing the identity of a pseudonymous defendant. I finally got it right. What was that, like the fifth try?
Yeah.
The subpoena in the present matter was served on Reddit January 24th. Dark Spilver was notified February 7th. Did not file a present motion until March 26th. Neither Dark Spilver nor his counsel reached out to Watchtower to negotiate an extended deadline. There is no excuse for such a delay. Dark Spilver's counsel provides no excuse for its 50-day delay in filing the motion. Was it 50 days? Is February 7th to March 26th? Yeah, I guess that could be close to 50 days. Counsel provides no excuse why it took more than 30 days after being retained to file the motion. More importantly, counsel states no reason why they never requested more time from the court to file a motion to quash. Okay. If a judge wants to be strict about that, the judge probably has it within their discretion to be strict about that. Then they go on to say that Dark Spilver has not satisfied his burden of proof on his motion to quash. And this is the core of the matter. Finally, we're only 13 pages in and we get to what the burden of proof is on a motion to quash. Dark Spilver, is that the Redditor? Yes. Dark Spilver, not Spliver. It's Spilver. I don't think I'm violating anything by using the right person's username, but it's all over this document, and I really don't feel like redacting it out. So I'm sorry, Dark Spilver, if you're getting more attention than you wanted. Wasn't my intention. So they say that Dark Spilver bears the burden of proof by preponderance of the evidence that he is entitled to quash the subpoena. Most of the time, quashing a subpoena means either showing by preponderance of the evidence, like they said, that you are either that the information sought by the subpoena is privileged, and that's a legal level of privileged, as in like part of a confidential investigation going on by the government, or you have some sort of diplomatic immunity, or the information is otherwise protected by another court order or something like that. This is not, I just think my private information is privileged. This is a legal level of privilege that you need to have established before you got here. Or you can establish now by filing something like a motion for a protective order, which has not been filed here. The second possibility for quashing a subpoena is called an undue burden. And it is also a very high bar to meet. You have to show that the burden on the defendant is undue, that the information sought is somehow going to burden the defendant in some legally recognizable way. And someone's name on an account is almost never considered an undue burden, let alone that the burden for producing the information is on Reddit, not on Dark Spilver. Dark Spilver has to do nothing here for the information to be released. The opposition is what they're doing to try and prevent the information from being released. That's not part of the undue burden. However, us defense attorneys will definitely make the undue burden argument by saying that the defendant has to respond in court. That doesn't really get very far, but it is, in my humble opinion, a factually accurate thing that my client is often very, very adamant that they really don't want to go to court. And if I may be so bold, aren't we in court over something that seems to be tremendously small here so far? I haven't revealed the second document yet. Well, I did a little bit, but we haven't gone over the second document yet. So maybe there's something in the second document that they don't want the world to see. Accordingly, Dark Spilver bears the burden. They point to no physical presence in the United States. I don't know that that's part of the undue burden argument. Dark Spilver points to a map that participants have made. I don't understand how that's part of an undue burden argument. He provides no additional evidence that the community's self-made map is accurate. I don't think this says anything. I didn't read anything in the previous thing that the map had anything to do with his argument that it was an undue burden. Yeah. His argument that it was an undue burden was that they are not seeking his identity for copyright infringement purposes, but for an ulterior motive, and that's a misuse of copyright or other not proper use of copyright, and that his posts are fair use anyway.
Also, he did not add the map as an exhibit. That was
right. They did.
So
yeah. Dark Spilver's brief states that he posted the infringing material for a group comprised of primarily U.S. readers, when in fact only 2,869 of the subscribers have contributed to the map. What? Okay. Thus, the evidence of Dark Spilver's United States-based audience has nothing to do more than showing approximately 5% of his audience claims to live in the United States. I don't understand why this has anything to do with a motion to quash argument. Even if the court were to find that Dark Spilver was entitled to First Amendment protection, he is not satisfied his burden to prove that his claims of hardship are anything more than pure speculation. Okay, that right there is an argument. Dark Spilver would like the court to believe that the minute Watchtower learns his true identity, he will be unceremoniously excommunicated from his local church, and all communication with his friends and family will forever cease. A fact of the matter is that Watchtower is not Dark Spilver's local church and has no ability to excommunicate him from his local congregation of Jehovah's Witnesses. Okay, well, you can't say on one hand, out of one half of your mouth, you're saying that it's pure speculation that he's going to be excommunicated. On the other half of your mouth, you're saying that you know for sure that you're not even going to be able to excommunicate him. You don't know who he is, right?
Yeah.
So if you don't know who he is, how can you say which it is? Right now, we're in the Schrodinger's box of who is Dark Spilver. Watchtower can't say for certain that they do know things, while in the same paragraph saying that they don't know things. Whatever. Finally, Darkspilver points to no proof that Watchtower has ever publicly disclosed the names. This is a lot of speculation about past and future. A burden argument is really a present argument. It's an argument that it's a burden on them presently. Evidence submitted in support of Dr. Spilver's motion to quash acknowledges that their claim of eternal isolation from friends and family is not accurate. It goes on to say that, look, they have this community of Jehovah's Witnesses on Reddit. Finally, Darkspilver claims that compliance with the subpoena will result in complete social isolation, overwhelming negative effects on physical and mental well-being, yet Darkspilver acknowledges that there is a large community of supporters with his views. Okay, I mean, they do get to choose who is in their organization and who is not. It is a private, members-only organization. However, again, using copyright to resolve all this is just weird. I'm not saying it couldn't be copyright infringement, but this is a very weird way to go about it. Like, most copyright infringement cases don't look anything like this. Further, Darkspilver has provided no proof that his physical and mental state will be actually affected. Okay, fair enough. It is clear that Darkspilver's claim of harm will necessarily result from compliance with the subpoena. They're nothing more than speculation. Whatever the intended purpose, the declarations that he submits in support of his claims of harm actually prove that compliance with the subpoena will not result in the complete obliteration of his relationships. That's a weird thing to say. And especially while they're simultaneously saying that they won't destroy his relationship with the church, then they're going on to say, but even if we did, he's got other people.
Yeah.
That's weird. Watchtower is entitled to compliance because there's infringements, and they need to redress that with a court. And they've complied with Section H and the test for such a subpoena. Let's see what the Highfield's test is. Highfield's case is factually distinguishable, so they don't want to be under Highfield's. Let's see why. On the most basic level, Highfield's capital management case has nothing to do with copyright infringement or DMCA subpoenas. Highfield's case involved claims for trademark infringement, false designation of origin, defamation, and commercial disparagement. Unlike the subpoena at issue in Highfield's, the subpoena issued in the present matter does not stem from a John Doe case for which a complaint has already been filed. So they're saying this is procedurally different, so Highfield's should not be allowed. And that the defendant in Highfield's was not a non-resident foreign national. Even if the court applies Highfield's, we think it doesn't matter. Highfield's court required the plaintiff that they first show real evidentiary basis for believing the defendant has engaged in wrongful conduct that has caused real harm to the interests of the plaintiff and the laws plaintiff has invoked or intended to protect. Yeah, that sounds pretty nice. So if they apply that test, the court will require the plaintiff to show their evidence for the copyright infringement and what their damages are. And that should help flesh out how really undamaging, or should I say de minimis, this is. And I think now might be a good time to go over the second chart, the chart, basically. Yeah. So there was allegedly this flyer and this chart, and we already revealed one of the charts. So this is Exhibit C to the well, I almost said complaint, to the motion to quash. And this is the chart that's alleged as copyright infringement. This looks like it's titled Name and Contact Details of Data Controller. And this looks like a type of record. So under the heading Type of Record, Notice and Consent for Use of Personal Data, Article 31F or 1A. Okay, 31F is this section. See instructions for use of personal data. Now, what do we know about Article 31 or 30? Excuse me, Article 30 and data retention. That sounds an awful lot like something from the EU, the GDPR.
Yes.
And can anyone confirm that? Okay, yeah. It says up here underneath the document 8-4, Article 30 of GDPR. So this is their data compliance chart. their GDPR compliance chart as to who they're going to who's going to handle and how they're going to handle different types of congregation data under the GDPR. Now, this looks fine. Like this, I'm not like looking at this going, oh, we found the smoking gun. The Jehovah's Witness organization is going down. So I'm really not sure what the big deal about this is. This is a very basic thing. It just lists out who is going to be working on or how they're going to be handling various different types of consumer or congregation data. And that's something that would be required under the GDPR.
Yes.
Now, here's a second problem that I have with this, though. What do we know about data? In its most basic sense, we've gone over a couple different cases, including the telephone book case. Was it Geist Publications or something like that? Feis. And the telephone book case said that you can't copyright facts. If you remember the telephone book case, Feist Publications, I think it was, Feist. There was the defendant, the plaintiff, try to get my parties correctly. The plaintiff had published a telephone book, and they had put 4, I believe it was just 4, fictitious numbers into the telephone book to find out who was copying their telephone book. And sure enough, there were lots of people copying the telephone book. And so they sued the defendant over the alleged copying of the telephone book. And the judge said, well, you don't have any copyright in people's telephone numbers. You can list out people's telephone numbers from A to Z, and there's 0 copyright infringement involved in someone copying all of that. However, you did copy the 4 fake numbers, and that's copyright infringement. So it was ultimately found to be copyright infringement. Now, this chart, which I'm not going to keep revealing because I want to make sure I stay a fair use, this chart seems to be a chart of factual data, of company policies on private data. The words could technically be copyrighted, but this is more of a factual thing. So I would almost be arguing that this couldn't even be copyrightable because it's just a chart of factual data.
I'm pretty sure that maybe not me, but I mean, someone could even request this information, because this basically lines out how they're gonna be handling my information, and I'm allowed to ask this part, like, what will you do? Like, how long are you gonna store it? And this is exactly laying out how long they keep my information, who they're sharing it with. So this is kind of still public information in a way, because it can be requested.
Thank you, Aspernari, for the $20 donation. Really appreciate that. The chart, however, could be copyrightable on a very, very basic level. That, yes, copyright protects a work that is fixed into a tangible medium of expression. And this chart has words that are fixed into a electronic medium that can be transmitted and perceived by a recipient. And that meets the minimum definition for a copyrighted work from the procedural standpoint. And then we do have to look a little bit at its substance. Is there anything in here that is creative, that is minimally creative? And by minimally creative, I mean very, very minimally. And I don't really see too much here. A little bit of a color on the heading. This isn't to me, this does not represent a creative work. However, a court could disagree, and we would have to go to a more in-depth analysis of whether this chart contains even one cell of fictitious data, or whether the arrangement of words on here for compliance with the GDPR does actually reach a level of copyrightability. But I am extremely skeptical that this chart, which I realize we're not looking at anymore because I don't want to be guilty of copyright infringement either. I don't want to be sued by Watchtower Bible. That chart is somehow copyright. I'm extraordinarily skeptical. I do not personally believe that chart is a copyright protected work. So if I'm a judge in this case, I'm looking at the arguments that are made here. I'm looking at the evidence that we've seen with the flyer and the chart, and I'm really wondering what the true dispute is here. And I don't think a judge is going to be able to overlook the EFF and Darkspilver's arguments that this is a cover for uncovering the identity of someone who has upset a religious organization and purports to be either a former member or a current member. And this is a mole hunt, not a witch hunt, because I don't think the argument is that Darkspilver has committed any sort of witchcraft. I think the argument is that Darkspilver has revealed internal confidential information. Now, here is where I start to get a little uppity, because if Darkspilver has been a member of the organization and is revealing confidential information, is that not something under contract, not copyright? Don't we know another organization, Scientology in California, that has its members sign various confidentiality agreements? And those agreements we've seen here and there over the years in various different revelations, movies and documentaries and things, because this sort of things happen. These sorts of things happen. A disgruntled employee or disgruntled congregant leaves the church and wants to tell everybody what they were subjected to. And someone like Scientology, which I still find to be a very strange thing, that a fiction book author has created a religion that is now very expensive and charges people lots of money. I don't understand it. Can I just write a book and you guys will all follow me as part of a religion? That'd be kind of cool. A little weird though. Still find that weird. But why couldn't, or why didn't, and I'm a little bit suspicious that they don't, why doesn't Watchtower have a confidentiality agreement with Darkspilver already? And if they do, isn't Darkspilver in violation of that confidentiality provision? That's how this should be done. I'm not saying that it should be done at all, but that's how I believe this should be done. Let's keep going. There's only a few pages left. While Darkspilver does not contest Watchtower's ownership of the article, he was able to find the copyright registration record for it. He contests the viability of their claim for the chart because he cannot find a copyright registration certificate. Let's see. Unlike the article, for which was intended for public distribution, the chart was an internal document which was not intended for public distribution. For that reason, the article was registered with the Copyright Office. Once the infringer is identified and personal jurisdiction over the infringer is established, the chart can be registered via U.S. Copyright Office special handling process designed specifically for expedited processing. That's another problem. So if the chart is not copyright registered, there are a different set of rules that apply. Now, we did read the case, I forget its name already, where the court said, I believe the Supreme Court said that you need to have a copyright registration before you can sue.
Was that the one with Ruth's father Ginsburg?
Rimini? Or something?
Rimini Street was the one about costs.
Oh, darn.
Good guess, though. The Supreme Court did say that there was special treatment for unpublished works. And I honestly don't remember what that was. So, bad copyright attorney. But for unpublished works, there was some kind of special treatment. So I'm gonna in my mind give them a little bit of leeway here and say that, okay, that was an unpublished work, therefore at least maybe they have some leeway in registering it after they're taking legal action or while they're taking legal action. However, if I recall, this is starting to flood back. The court also said that sort of protection was for a specific kind of unpublished work, and I thought that was motion pictures and music, and not for religious charts about data privacy protection under the GDPR. So while I got a bit specific there, I'm skeptical that the courts are actually protecting this kind of work.
The case was Fourth Estate v. Wall Street.
Fourth Estate, thank you. Fourth Estate v. Wall-Street.com, I think it was. It can, while Watchtower obtains sufficient information, or when Watchtower obtains sufficient information to identify defendant, it can easily apply for copyright registration and can recover for infringement that occurred both before and after registration, citing Fourth Estate Public Benefit Corporation. Simply put, copyright registration does not confer ownership of the work, and Darkspilver never contests Watchtower's ownership of either of the works at issue. Mostly my issue is whether their copyright works at all. The first one, the flyer, is definitely a copyrighted work, and then I think then we can go on to a fair use or de minimis analysis from there and decide for ourselves whether it's copyright protected and violated or not. The chart I'm having I'm having more of a trouble with, or less favorable to. They argue about the Highfields case again, which required a comparison of the magnitude of harms that would be caused to the competing interests. Okay, so the magnitude of harms that would be caused to the competing interests, it does sound like there's some great disparity of harm here. It sounds like there's zero harm. I don't mean that copyright infringement couldn't have been committed, but even if it was, what is the harm? What great harm did I almost said Mormons. What great harm did Watchtower Bible and the Jehovah's Witnesses suffer because their GDPR policy was revealed? It sounds to me like they're upset that they have a mole or a leak, which they have every right to be upset about, and they want to find that mole, root him out. We want to talk to him.
Oh, God.
They want to talk to the mole. So that's mostly what I'm concerned about. I think Darkspilver has a genuine concern here. I wouldn't want to be on the wrong side of the Watchtower Bible and Tract Society. So the magnitude of the harms would be the harms that Darkspilver is citing in being rooted out of his community, existing community. The XJW community is not what we're talking about. That's what Watchtower Bible is citing as he already has a community, so he doesn't need ours. But I don't think that's the standard. I think the standard is based on the status quo, where we are now. And where we are now is he's got the XJW community and not Mormons, Jehovah's Witness community, or at least whatever community that he does have. So I think these are valid concerns. Let's keep going here. An evaluation of fair use at this stage would be premature. An evaluation of the merits of the underlying claim, much less the affirmative defense of fair use, is premature, citing Authors Guild v. Google, a Second Circuit case, which is only persuasive argument for here. As the Supreme Court has designated fair use as an affirmative defense, the party asserting fair use bears the burden of proof. That's Campbell v. Acuff Rose. Again, means nothing right now. Because fair use is an affirmative defense, the defendant carries the burden of demonstrating it. Again, means nothing about the timeliness of the defense. Making a ruling on whether Darkspilver's use of Watchtower's intellectual property constitutes fair use would be effectively a ruling on a 12b6 motion to dismiss. No. There are other ways to dispose of a case, and just because a case can be disposed of using fair use, or just because a case can be disposed of using some motion or basis other than 12b6, which there's 5 others before it, doesn't mean that it's effectively ruling on a 12b6 prematurely. No. However, even if a court were willing to make such a ruling, Darkspilver's use of Watchtower's copyrighted work is not a fair use. The first fair use factor evaluates the purpose and character of the use. In addressing the first factor, the court asks whether the new work merely supersedes the objects of the original or instead adds something new and is transformative. Defendant admits that he posted a copy. So yeah, not transformative, doesn't really look favorable under the first factor. Yet, Darkspilver admits that the original file was an Excel file that had to be viewed to be read on screen. He concedes that he merely replaced the object of the original creation. Okay. The second factor examines the nature of the copyrighted work. Darkspilver acknowledges that the creative design of the article is one of the reasons he produced it for Reddit. Is that what he really said? Let's see his declaration. We can actually go there and see his declaration. This is the declaration of John Doe. He is the owner of the Reddit of the Reddit user account Darkspilver. Wish to maintain my rights to free speech, associated religious rights. My parents raised me as a Jehovah's Witness. I've been a member of the community my whole life. My friends and family today are active Jehovah's Witnesses. So he is not a disfellowshipped user or worshiper in the Jehovah's Witness organization. So I still consider myself a practicing Jehovah's Witness, but like people of many faiths, there are aspects of the organization's teachings and practices I have issues with. I wish I could openly discuss my views with other members of the community, but unfortunately, these opinions are strongly discouraged. In my experience, people who voice their disagreement or doubts ultimately face rejection and disapproval from other members, including leadership. Those who depart from the organizations are labeled apostates, excommunicated, and disfellowshipped from the community. When people are disfellowshipped, no one will talk to them from the community. I have personal knowledge of people in the community who have been shunned by Jehovah's Witnesses due to the opinions they have voiced. For approximately the past few years, I have participated in Jehovah's Witnesses subreddits. I do not consider myself a former member. It is the only place that I have to discuss and debate matters related to Jehovah's Witnesses freely and openly. I chose to participate in the community on Reddit instead of other social media platforms, largely because they allowed me to use a pseudonym. Keeping my name and identity private is necessary for me to feel comfortable participating in open discussions. I am a foreign citizen residing in their country of citizenship, but participants in the subreddit are based in the United States. Okay, it's an interesting, I mean, he's doing the same thing. It almost doesn't matter how many people are participating in the United States. What matters is his minimum contacts. Yeah. International Shoe and Bell Atlantic v. Twombly, minimum contacts with the forum state is what we care about. And the minimum contacts is his posting on Reddit, on their servers, and yes, interacting with many other community members through the United States-based organization. Jehovah's Witness organization is also based in the United States. Let's see. It is my understanding that the two images I posted online are the subject of Watchtower Subpoena. The first is a copy of an advertisement from the November 2018 issue of the Watchtower magazine. I posted it on the former Jehovah's Witness subreddit, and attached is a true and correct copy of my post within the community and my comments with the other users. To my knowledge, the Watchtower magazine included in the issue appeared for free, etc. So let's take a look at that. That was Exhibit B, right? So let's take a look at what Exhibit B is. This is the actual post on Reddit. Yeah. And it says here, what gift can we give to Jehovah? Guess what? WT Magazine, full back page advert, and then there's a bunch of comments here. Now, let's see if I can find, I don't know if this is text. Let's just search for Jehovah, because this is, I don't think this is... Is it? Okay, it does look like it's OCR'd. So then let's find Darkspilver. I don't have any matches. I don't see a single comment by Darkspilver. Mm. So the question then becomes, was Darkspilver posting this as a with commentary? And we can't tell. We don't know because it says here that the original poster was deleted and the original post was deleted.
Mm. Well, don't we have also Exhibit A posted by the Watchtower that's still... No, by the other party.
By the other party? Let's take a look. This is Watchtower's Exhibit A.
Okay. Then it's B. Sorry.
B?
For some reason B is before A.
Yeah, that's probably just the way it got opened.
So... No.
No, this is the EFF somewhere. Baxa thing.
I remember it wrongly, but
if we take a moment, we can probably find it on removedit.com.
I thought they also posted a screenshot that still had everything there because I've seen it. I know I've seen it.
Okay, well, let's go through them real quick, one at a time. Exhibit A is the flyer.
Yeah.
Exhibit B is the deleted post.
Yeah, C and D are the charts.
C and D are the charts. I'm not sure why there are two charts, but this is a second chart. That's their declaration. That's Watchtower's declaration. That's Watchtower's post, but with everything blacked out. Yeah. Or Watchtower's exhibit, but everything blanked out. This is the EFF backs Redditor page. This is the geolocation page. What is this?
There.
Here we go.
See. I'll get there.
Full back page advert. And then are there any comments? We don't know. It doesn't look like it. They're making the point that there's 34,000 users in 1 month, and that's what this was for. 29,000 subscribers in 1 month and 34,000 6 months later or whatever. However, this doesn't tell me if there were any...
Nope.
Yeah, so Joan LB is asking the same thing. Did removed it cache it? So let me put myself full screen and I'll go look at it on removed it. If I can actually find I need the original though. I need the original post, and I think it's been.
There's a link there.
But that's going to be really hard to get. I'm not going to be able to OCR that. That's absolute garbage. Give me 1 second, everyone. This is in the XJW subreddit. Let me see if I can find it just real quick here.
Let's turn up.
God damn it, Reddit. Jehovah?
You wrote Jehovah wrong.
I wrote Jehovah wrong.
God damn it, Reddit.
I am not seeing... Of course, Reddit's search engine is notoriously terrible. So, if somebody can find it on removed it, I'd love to see what it actually said. So far...
What's the name of it? The name of the post?
Also,
here, I'll bring it up here.
Short link?
Oh, we can use the short link. Duh. Let's see if it's even up on Reddit anymore. Okay. So then... Yeah, not found. Did I do that right?
What's that? What's that someone?
I think I did that right. So this is what gift can we give to Jehovah? And if we type, you want to try set it? Let's try set it. Yeah, it's also got everything deleted. So, sorry, that's not very much help there. What else do they have to say? Third fair use factor. Do we get through the second one? The second fair use factor requires the examination of the nature of the copyrighted work. Darkspilver acknowledges that the creative design of the article, that's where we were, is one of the reasons that he reproduced it on Reddit. See declaration at paragraph 3, line 28, or page, maybe it's page 3, line 28. Let's go back there. This is page 3. I shared the image of the ad to show how openly the organization was petitioning for financial donations from members, to illustrate the organization's use of commercial advertising design, and to point out the organization's encouragement of online donations. So that's a little bit disingenuous of them to say that he's only posted it for the design of the article, but okay. Okay, they do say one of the reasons he reproduced it on Reddit. Moreover, the illustrations, layout, and word choice in the article are all creative in nature. I don't dispute that it could be that the article is likely a copyright protected work. The third fair use factor is the amount and substantiality of the portion used. I felt that was short too, but that was the entirety of their second fair use defense. Their defense against the argument of fair use was that the layout, design, and word choice are creative. That's it. Third factor is the amount and substantiality of the portion used. Darkspilver admits he reproduced the ad and chart in their entirety. Of course, remember the ad is one page of a magazine, so the copyrighted work as a whole is going to be taken into account, not just the back page. Darkspilver claims that he had to use the entire work. Well, he didn't use the entire work. That's not how that works. But that's for the EFF to argue, and that's for the judge to rule on. Doe provides no reason why his purpose could not have been accomplished by linking to the article and summarizing the chart. Okay. The fourth fair use factor evaluates the effect of the use upon the potential market. Courts decide whether the unrestricted and widespread conduct of the sort engaged by the defendant would result in substantially adverse impact on the potential market for the original. If widespread unauthorized reproduction and display of Watchtower's works online were permitted, there would be virtually no need to visit Watchtower's website. Well, except for the donations you're asking for in the copyrighted work. Doesn't that change it a little bit for you? Like, we're not talking about Darkspilver posting a Vincent van Gogh original or copy of it on Reddit. We're talking about Darkspilver posting a flyer that says, you can go see Vincent van Gogh here at this museum. And he's not doing it with the authorization of the museum, and he's using the museum's flyer. If I went and copied a museum's advertisement flyer and distributed it myself without commentary, admittedly without commentary. Now, the commentary could be implicit. He says that he meant to do it to expose things and make commentary otherwise, but I didn't see his direct explicit commentary, so there's at least an argument that there's no commentary. Yep. So if I'm... I don't know, what is a private museum? Is Museum of Modern Art a private museum? I don't know. Let's say that I'm taking a private museum's flyer advertising their Van Gogh exhibit, and I'm reproducing the flyer that says, go here to see Van Gogh, and you'll have to pay us money to get in. I haven't made any money. I haven't taken away your money. The Van Gogh exhibit's still there. I've not infringed on the exhibit itself. It sounds an awful lot like I've just posted your flyer around for you a lot.
And creating more traffic.
And maybe you don't want to do that. Maybe you don't want me to do that. So yeah, I think there's some kind of copyright involved, but there's no damages involved. All right, so I'm skeptical there. Diverting traffic away from Watchtower's website could result in significant decline in readership. Really? Really? Look at this. Diverting traffic away from Watchtower's website could result in significant... They literally just argued a few minutes ago about how we can't talk about mere speculation in Darkspilver's damages or burden on Darkspilver. But here they're saying that their website will have a significant, could have a significant decline in readership because Darkspilver posted a donation flyer on Reddit.
We can't speculate unless it's in our favor.
Do we buy this at all? Wow. Okay. So I'm sorry if I'm getting a little hyperbolic there, but that's just, or a little bit energetic there. And that was it. That was their entire fourth fair use factor argument. And then they conclude that Watchtower has the right to pursue legal action because it believes in good faith that there's an infringement of an intellectual property. And I have my doubts I have my doubts that this is a successful endeavor. However, like I said before, the burden on a defendant in a subpoena matter like this, some courts don't believe there's much of a burden, even when we argue about bad things happening to defendants. Most of the time, though, I'm arguing that the bad thing happening is that the defendant is going to have to defend the case. There is no lawsuit yet here. This is just a subpoena. However, the expected response will be that the Watchtower Bible organization, upon getting Darkspilver's identity, will do something Darkspilver doesn't want them to do. And specifically, that Darkspilver will be excommunicated from the church, and his friends and family instructed not to talk to him anymore. That sounds like a great burden, actually. I just don't know whether a judge is going to give it credence. And that's what I'm mostly concerned about, is a judge needs to see this and take it for what it is.
Yeah.
And the EFF could make a very good argument, but the judge might disagree. Now, I didn't see who the judge is. Let's take a look. Who is our judge? Judge Magistrate Sally Kim. We've seen Sally Kim before, I think, in one of our other cases. And I seem to remember something about her. I remember her being fair. So I don't think that we're in any danger of a judge not taking these arguments seriously. But it is within a judge's discretion to decide matters of discovery broadly. So the judge could decide against Watchtower, and the judge could decide against Darkspilver, and the judge is probably not wrong. The argument on appeal would have to be whether the facts were the judge said they were, or found that they were, or whether the parties actually presented an argument that reached the requirements for the subpoena or for fair use. So far, I'm skeptical about the fair use offense from Watchtower. They seem to have spent very few sentences on the fair use argument, whereas it seems like the EFF's arguments are going to be very strong.
Yeah.
In either that it's a de minimis use, that it's a fair use, or just simply that the subpoena, the balance between those Hightower factors that we saw, that the balance between the burden on the defendant and the need of the plaintiff is so different. There's almost no legal remedy. What is the legal remedy for this copyright infringement? I mean, this is to me such a minimal copyright infringement that it's hard for me to see what is the cost? What is the damages involved with reproducing your GDPR chart and the back of a flyer or back of a magazine, which is a flyer asking for donations? Yep. I don't see it. I don't see how this is a great copyright case. But I could be wrong. I've tried my very best to acknowledge that Watchtower can make copyrighted works and they can be protected. And if they make, let's say they make a Van Gogh painting, obviously not Van Gogh, but let's say they make a painting with colorful oils on canvas. Doesn't have to be good. It doesn't have to be a masterpiece. Just any creative effort on canvas is fine, as long as it's fixed in a tangible. If that copyrighted work is posted on Reddit without commentary, yeah, that's not allowed. That's copyright infringement. Yeah. If someone posts commentary that says, here's the entire work in a high-resolution copy, I just don't like it. It doesn't sound very much like a fair use either. But if someone says, I can't believe I almost did it again, Mormons. The Jehovah's Witnesses, I can't believe the Jehovah's Witnesses spent all their money commissioning a painting. This is a terrible travesty and a misuse. That's a fair use. And if it's, especially if either all of the work is posted in like a lower resolution format, or maybe somebody links to their web copy of the work or something like that. Darkspilver could have, if they had known of this ahead of time, could probably have avoided this by having added more commentary to the posts.
Yeah.
Simply having Redditors comment on the posts, I don't know if that makes it a fair use. I think the commentary has to be from the infringing person. And what I'm concerned about is that this doesn't have any... this doesn't look... Go ahead.
He did editorialize the title a little bit, which brings me back to the Sargon of Akkad and the Aquila Hughes thing, is how, like, can you do a quote-unquote, like, creative edit and then change the title to something, and is that enough commentary?
That'll be one for the judge. That I'm not sure. The title has a few things in it, but maybe if there's something in the title that's what was it? It was what gift can we give to Jehovah? Guess what? Is guess what enough of a commentary to make it a fair use automatically? I don't think so. I think some of the other fair use factors go in favor of some kind of fair use or de minimis use. Let's take a look at that before we take the stream out, because we've been talking for an hour and a half about this.
Yes. Kitty. Let's have kitty.
De minimis use here is a Latin expression about minimal things. Normally only the locutions de minimis non curat praetor. The praetor does not concern himself with trifles, or the law does not concern itself with trifles. A legal doctrine in which a court refuses to consider trifling matters. The general term has come to have a variety of specialized meanings. Let's see. We'll go straight to copyright. Courts will occasionally not uphold a copyright on modified public domain material if the changes are deemed to be de minimis. Similarly, courts have dismissed copyright infringement cases on the grounds that the alleged infringer's use of the copyrighted work, such as sampling, was so insignificant as to be de minimis. However, in one case, Bridgeport Music v. Dimension Films, such a ruling was overturned on appeal, and the U.S. Appeals Court explicitly declined to recognize de minimis standards for digital sampling. Let's see, in education, Individuals with Disabilities Act requires more than de minimis efforts to provide... Yeah, that's something completely different. Okay. So that's de minimis use. And a court could... Thank you, $5 from the Watchtower Society. And a court could decide that this use is so minimal or trifling as to not be worth adjudication at the court's level. So... Interesting case. I also think this is a trifling matter in my humble professional opinion, but let me, of course, I don't want to try and hide this. I'm a defense attorney. I defend people from copyright cases a lot because I believe that the core of copyright is meant to protect creative works, and this kind of dispute over a flyer and a chart, I don't believe that is at the core of copyright. I don't believe these are the creative works that the founders intended to protect. I don't believe that the slippery slope argument that Watchtower is making is valid in any way. I don't see any damage coming to the Watchtower Bible and Tract Society from this case, or my coverage of it, or Darkspilver's posting of their flyer or posting of their charts. Could there be a case in the future where the post was so damaging? Yes, I could imagine a couple scenarios, but that would be much closer to where they had commissioned a painting and the painting is being copyright infringed. Something like that. If the Watchtower Bible and Tract Society commissions an album of Jehovah's Witness music and that is posted to Reddit without any commentary and posted in its entirety, yeah, that's absolutely infringement. People would be able to download the image or the music or something and not have to go to the Jehovah's Witness organization or their website. So yeah, that's copyright infringement. It is not This is not what the core of copyright was meant to protect, in my humble opinion. Do we have anything that we've forgotten to go over? Let's see. Misuse of copyright is a defense that the EFF or Darkspilver could present, that this is not the proper way that copyright was meant to be used, and therefore the plaintiff should not have their copyright recognized as protected in this case and possibly other cases. Yeah, I think we've covered it all. Yep. Are there any other questions? Otherwise, I'm going to take the stream out, and we'll call it a night. It's pretty much midnight here in Scotland. What?
I was wondering where the music came from.
You were wondering where the music came from? So it is midnight here in Scotland, so some people are a bit tired. And maybe a little bit flaky.
I just wanted to quote Mute Vampire that you literally can't comment on an image post on Reddit. Like, you have to go into the website part and comment separately for the image posts. And because I'm not sure that we have an image of the post before Darkspilver sort of deleted stuff.
Right.
Like, he could have commented in the main comment section.
Yeah.
I also think his guess what could have been a stronger commentary if it was in the context of a conversation. For example, like if so it's like all of the gifts that you could give Jehovah, like your love and devotion and pursuit of holiness and volunteering and all of that. This one specifically talks about all the ways you can donate money.
Yeah.
So I think there's a little bit of, like, depending on the context, you might be able to understand the commentary of guess what.
True. There could, yeah, that is a very good point. The account was deleted and the post contents were deleted, so we don't actually know if there was commentary from Darkspilver in the comments. There could have been further comment, and if that's true that Reddit doesn't allow you to comment, then there wouldn't have been anything written there anyway. Yeah, depending upon how the image was uploaded, if we're doing a link to Imgur, then I think you can just put the link in the in the text, and then like Reddit Enhancement Suite and stuff will allow you to pop that out, and we'll show you the image and all that without clicking on the link. So I'm used to surfing Reddit that way, so I'm a bit privileged in that sense, that's always automatic for me.
Yeah, if you want Reddit to do it automatically, you need to upload it, and you can't write text.
Okay, so we would be looking for comments in the comment section, and we didn't have a cache of that comment section, so that will be part of it too. There could very well be commentary from Darkspilver in there, and if Darkspilver does use this as their community, then I would expect that he would have had various comments in that discussion, and that would make it much closer to a fair use. Same thing with the GDPR thing. So what do we think? I'm gonna have to start another song. Let's see, what's one of my favorite ones?
I think everyone just loves the cats.
Yes.
I was so worried that the chat would not behave. Turns out, best way to get the chat to behave, just put cats on frequently.
Nice.
Everyone gets struck by cats.
Well, thank you, chat, for behaving. We only had one or two people in the beginning that were saying nasty things and had to be removed. And so I'm glad that you didn't stress out my mods. Thank you to all of you for joining us this day, this evening, this night, for this wonderful live stream on YouTube with none other than me, Leonard French, your favorite copyright attorney and proprietor of Lawful Masses, our legal education channel on YouTube and Twitch, and our effort to educate you, the lawful masses. Thank you to our Patreon and Twitch supporters, as an extra P in supporters, the Suppporters. At the $50 level, John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Michael Pearce, Terry Crisp, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, Aspernari, Snorre Wisotzky, Sean McNamara, and Aetaric, thank you very much for your support in April at the $50 level. We also have many $5 plus supporters who will be, well, I don't know if I can make you scroll on the screen because this is going to be a VOD on a live stream. So you're going to be in the description of the video below. You might already be there. We are a community-supported organization. Thank you for all the donations today on stream. We have a very interesting story coming up. It turns out that Kim Kardashian West is pursuing a law degree. So we're going to explain how and why, and I think I'm going to put my full support behind the effort because I really can only see good things coming out of this, even if I may personally not be a Kardashian fan or a Kanye West fan. I'm more with President Obama on that. But, you know what? I can't see anything bad coming out of Kim Kardashian West becoming a human rights or criminal defense lawyer. More power to you. So we're going to do our next show tomorrow will be a video, regular video, on that subject. So check out our channel tomorrow, subscribe if you're not, and watch our video on Kim Kardashian becoming a lawyer. All right. Thank you for joining us. I am Leonard French, your favorite copyright attorney. Love you all. Have a good night. Bye. We swear we're not torturing a cat. We just love the cat very, very much. And she exclaims how much she loves us back. Often. I swear. All right.